Ninjani molweni afsheni thobela nda. Guys, here we are with the FUR2601 fundamental rights. We are here and it's assignment 2 for semester 2. We can see the question number 1 there, question 2, question 3, question 4, question 5. Which questions we must start with, guys? Okay, let us start with question 3. Explain in detail the constitutional jurisdiction of the following courts: Magistrate, High Court, Supreme Court of Appeal, Constitutional Court. So we are explaining in details about the constitutional jurisdiction, not just a litigation jurisdiction, but constitutional jurisdiction, where those courts are standing with a constitutional jurisdiction. Firstly, you must note that this video of FUR fundamental rights is for the advertisement. The other questions are answered on our members only, where you pay 100 Rand for a membership to watch all the questions. Once you pay, you will be eligible to see all assignments of all your modules. Regardless of how many modules you are doing, you will pay 100 Rand monthly to see all the questions of your modules. So even if you are doing 15 modules, as long as it's LLB, then you will be eligible to pay 100 Rand to see all your assignments. If your assignment question is not yet uploaded, please WhatsApp me on this number 0619842135 with the question so that I can able to upload such a video. Except online modules such as SJD, FL, and FAC, because these modules you only answer on the system. Therefore, you won't have a time to answer them outside of the system. Therefore, we don't really deal with these modules because they are system modules. They are online, but they are system modules, unlike other online modules that have a portfolios. Otherwise, if you have any module, regardless of these three, you can WhatsApp us the question. If you have paid the 100, you are part of the membership. Okay? Okay, have you ever heard something called creatures of statute? That's right. Lower courts do not have inherent jurisdiction. The reason for this is that they derive their powers from the particular statute that created them. Because of this, lower courts are sometimes called creatures of statute. The exercise of jurisdiction in lower court is therefore dependent on the extent to which its enabling statute permits it to exercise such jurisdiction. This is the best illustrated by referring to the magistrate courts. The magistrate court is often referred to as a creature of statute because it has been created by legislation and derives its power and competency from the Magistrate Courts Act of 1994 and has no authority that can be found within four corners of this act. In other words, it may only do what the act permits it to do. Since we heard that Magistrate Act only rely on the Magistrate Courts Act 32 of 1944, it's very important that we come and hear what the constitutional jurisdiction says in the Magistrate Courts Act. It's very much important that we come to the section 110, which talks about the pronouncements on validity of a law or conduct of the president. It reads as follows. Subsection 1. A court shall not be competent to pronounce on the validity of any law or conduct of the president. Subsection 2. If any proceedings before a court is alleged that any law or conduct of the president is invalid on the grounds of its inconsistence with a provision of the Constitution, or any law is invalid on the only grounds other than its constitutionality, the court shall decide the matter on the assumption that such law or conduct is valid, provided that the party which alleges that a law or conduct of the president is invalid may adduce evidence regarding the invalidity of the law or conduct in question. Therefore, even if the magistrate does not rule on the validity or the conduct of the president, however, you can bring the validity of the conduct of the president and they will be ruled on based on the assumptions. After running from the Magistrate Court, we go straight to the Constitution of South Africa 1996, and we must hear what the Constitution says about the Magistrate Court. Section 70 of the Constitution made it clear that all courts other than those referred to in Section 167, 168, 169 may decide any matter determined by Act of Parliament, but a court of status lower than the Court of South Africa may not inquire into or rule on the constitutionality of any legislation or any conduct of the President. This means that when we answer, we will write question 3, Magistrate Court. Magistrate courts are a creature of statute because it has been created by legislation and derives its power and competency from the Magistrate Courts Act of 1994, and there's no authority that can be found within the four corners of the Act. Section 170 of the Constitution, read together with Section 110 of the Magistrate Act, stipulated that they may not rule on the constitutionality of any legislation or the conduct of the President. However, the litigant may adduce evidence regarding the validity of the law or conduct in the Magistrate Court to ensure the constitutionality is not just ignored. We are done, then we are going to the High Court. Section 169 made it clear that the High Court of South Africa may decide any constitutional matter except a matter that the Constitutional Court has agreed to hear directly in terms of Section 167, which is exclusive jurisdiction, is assigned by an Act of Parliament to another court of status similar to the High Court. Any other matter not assigned to another court by any Act of the Parliament. So we have heard it. This means that we write that the High Court can decide any constitutional matter except for some matters that can only be heard by the Constitutional Court. A Higher Court can, however, rule on the constitutionality of an Act of Parliament, a provincial act, or the conduct of the President. Such a ruling will only come into effect once it is confirmed by the Constitutional Court. Then we are going to the Supreme Court of Appeal. When we come to the Supreme Court of Appeal, Section 168, we find that it's the same thing. It can hear all the appeal arising from the High Court, so it's the same thing. It means that on the Supreme Court of Appeal, the court can decide appeals on constitutional matters. There are, however, certain matters that only the Constitutional Court can decide. In addition, although the court can declare an Act of Parliament, a provincial act, or the conduct of the President unconstitutional, such an order will only take effect once it is confirmed by the Constitutional Court, which is the same as the High Court. Now we go to the biggest court, which is the Constitutional Court. Let's just see. Constitutional Court. Then this is 167. Constitutional Court may decide constitutional matters and other matters if Constitutional Court grants leave to appeal on the grounds that the matter raises an arguable point of law of general public importance which ought to be considered by the court, make final decision whether a matter is within jurisdiction. Constitutional Court also here dispute these disputes that have been listed here, which are many. Even the making final decision on the Parliamentary Act of Parliament. So those things are made by the Constitutional Court. So in brief, we'll say, therefore, when you answer, you will state it clear that it can only hear constitutional matters and issue connected with such matters. For constitutional matters, it is the High Court in South Africa. The Constitutional Court is part of the Court of Appeal and hears appeals against constitutional judgments of the High Court and Supreme Court of Appeal. However, there are certain issues that only the Constitutional Court can decide, and because no other court can hear these matters, in this regard does not function as a court of appeal. For example, only the Constitutional Court can decide on the constitutionality of an amendment to the Constitution. Finally, as mentioned, when a High Court or Supreme Court of Appeal declares that an Act of Parliament, a provisional act, or the conduct of the President is unconstitutional, the order will only come into effect once it has been confirmed by the Constitutional Court. Okay, we are done now. We are going to the cases. You know, we don't write anything without the cases, then we are going straight to the cases. Let me put it like this so that we can go. Nothing can work out without a cases. When we are writing things, you must include the cases. So we are going for the cases. Before we discuss cases, it's very much important to note that the full video is for advertisement and some questions are not yet answered. But once you pay the 100 Rand membership, you can able to watch all the questions of all the assignments of your modules that you are doing, regardless of whether you are doing 10 or 15 modules. You will be able to see all your assignments. And I said to you, if your assignment question is not yet uploaded, you can please WhatsApp us on this following number so that we can upload such a question on your members only, and then we will notify you so that you can able to watch such a video. I said that this is except on the SJDFL and FAC because they are only the modules that are written on the system. So those modules are not written, they are only available on the system. But other modules, you can bring any question. So this is the cheapest 100 Rand. You see all your assignments of all your modules that are available, the written one. Then it's very much important that if you see no question, no video of your question, please notify us and WhatsApp us. The first case will be S versus Bosak, where the court said the Constitution offers no definition of constitutional matter or an issue connected with a decision on a constitutional matter. Section 167, subsection 3, paragraph C, leaves that ultimately to the Constitutional Court to decide. Another case is the case of the Doctor for Life, which concerned with the constitutionality of the Choice of Termination of Pregnancy Amendment Act 38 of 2004, where the Act gave women the right to abort a pregnancy. The Constitutional Court declared the Act to be unconstitutional, not because legalizing abortion violated the right to life in the Bill of Rights, but because of Parliament, in passing the law, had not fulfilled its constitutional duty to take reasonable steps to ensure the public participation in the legislative process. The Act was unconstitutional not for the rights-related reason, but for failing to perform its constitutional duty. So this will be the best case to take on. I only used 2 cases, but the other cases, okay. Now let's go to journal articles. Seedorf argued that the fact that this provision uses the word includes means that constitutional matter are not limited to this definition. Thus, the Constitution does not seem to offer any clear-cut definition of constitutional matter at all. The Constitutional Court has not been proactive in providing an all-embracing definition of constitutional matter. Instead, the court has tended to decide on a case-by-case basis whether a particular matter raises a constitutional issues. This means that the first person that I will include is Seedorf, who talks about the jurisdiction in S. Wallman and M. Bishop as Constitutional Law of South Africa, 2nd edition. This one was Seedorf. Another one, Friedman argued that since this amendment, the Constitutional Court has jurisdiction not only over constitutional matters, but all over any other matters, if it grants leave to appeal the matter. Leave to appeal is granted by the Constitutional Court if the matter raises an arguable point of law of generally public importance which ought to be considered by the court. Then he said, this is a Friedman, note that the arguable point of law requirements excludes matter that only involves disputes of fact. Similarly, the Constitutional Court may not entertain matters involving the straightforward application of the law. This is Friedman. The Constitutional Court makes the final decision whether a matter is within its jurisdiction. This means that we will put divorce Friedman case journal article also. This means that you answer these ways and then you magistrate, High Court, Supreme Court of FUR2601, then you include this case and the doctor for life the way it was there, then you summarize, then journal articles which may be book, you include this one of CDOF, then P divorce, then you are done, you have a 25 marks. Don't forget, if you have many modules and you want to write assignment without any problem, you can actually pay 100 for membership on our YouTube. Then after that, you will be watching all your assignments of your modules. It will be easier for you to write all your modules and have time for studies. And then if you have no question that we uploaded, you can WhatsApp us on this number. We are determined to upload all the questions of the videos by first week of August. Then by the first week of August, we should be done with all the videos about the assignments. Thanks very much, guys, for watching. And let's support me, guys, so that I can come with more information so that it can be easier for your studies. Have a nice day.